Deleting a former employee's inbox may seem like a routine cleanup step. It happens every day. Someone leaves, HR notifies IT, and the account is wiped. Simple, efficient, done. But if that inbox contains emails that later become important in a lawsuit, that routine step can create a serious legal problem for the company. I'm Alex Rubin of Rubin Employment Law. One of the biggest misunderstandings employers have is thinking this matters only if the employee was fired. It doesn't. Just to be clear, this video is for informational purposes only. It is not legal advice, and watching it does not create an attorney-client relationship. For legal guidance, please speak to an employment attorney in your state. The real question is not how the employee left. The real question is whether litigation was reasonably foreseeable when the inbox was deleted. That risk can exist after an employment termination, but it also can exist after a resignation, especially if the employee resigned under protest, claimed they were forced out, had an unresolved HR complaint, or suggested they might speak with a lawyer. When a claim is foreseeable, the company has a legal duty to preserve evidence. That duty is called a litigation hold, and it starts earlier than many employers realize. It can be triggered before a lawsuit is ever filed. For example, when there is an EEOC charge, a demand letter, a threat of legal action, or a high-risk departure that HR or management has already identified as problematic. If relevant emails are deleted after that point, the company may face a spoliation claim. That means evidence was destroyed, either intentionally or negligently, after there was a duty to preserve it. Courts take spoliation very seriously. Consequences can include sanctions, including payment of attorney's fees, and adverse jury instructions which damage the company's legal defenses. In some cases, the fallout can be severe, and a standard IT policy usually won't save you. If your company routinely deletes former employee inboxes after 30 days, for example, that policy does not override the obligation to preserve evidence when litigation is reasonably foreseeable. It is also important to remember that preservation goes beyond email. It may include texts, Slack or Teams messages, HR notes, calendars, shared files, and payroll or timekeeping records. So, what should employers do? Make sure HR, IT, and legal communicate before anything is deleted. Build a litigation hold exception into your offboarding process. And when a departure raises red flags, get legal advice early. The law does not require employers to keep everything forever, but it does require them to preserve the right information at the right time. If you have questions about when to preserve employee communications or how to build a sound litigation hold process into your HR practices, call us at 973-787-8442. Email us at legaladmin@alexrubinlaw.com or visit us at alexrubinlaw.com/delete-and-regret.